Hi guys, and welcome to the new channel. We are going to watch. Fani Willis is currently having her emergency motion to quash and for a protective order because she does not want to appear at the for a deposition in Wade's divorce case, who is the special prosecutor that she hired to be the prosecutor for the Trump case. So I am going to stream this right now over here. I'm rewinding it back a little bit. So as you guys come in, make sure you know what to do. Hit the like button. Nothing has changed. Come on in. Come on in. And I'm going to get that started.
Session, Dr. Judge Henry R. Thompson is here.
Thank you. Be seated. All right. Ms. Hastings?
Yes, sir.
I'm Mr. Clyde, Your Honor. I am actually here on the second set of motions, the motions for access to the file, to unseal the file.
Where's Mr. Kimbrough?
Very good.
Oh, why don't you take that table?
Will do.
Your Honor, with your permission, I'm going to just sit up here.
That's fine. And Ms. Merchant?
Good morning, Judge.
Good morning.
I'm here for
And
the second.
I'm sorry?
I'm here as well for the second motion. So
Right.
I'm sitting back.
Why don't you come on up to the table as well? There's a chair for you.
Thank you.
And Mr. Axum?
Yes, good morning, Judge.
All right. Okay. Who wants to share in the takedown of this? Mr. Kimbrough?
Yes, Judge, we'll share.
Ms. Hastings? Ms. Merchant?
We'll share. Yes.
Okay.
We will as well, Your Honor.
Okay.
Thank you.
How about you, Mr. Axum? You want to share in the takedown?
Absolutely.
All right. Okay. This is Wade versus Wade. Civil action number 21-108166. And Mr. Wade is represented by Mr. Scott Kimbrough. Mrs. Wade is represented by Andrea Hastings. And we're here today for basically an emergency motion filed by Mr. Axum by a non-party deponent for a protective order. But there was already a pending motion to unseal the record filed by Ms. Merchant. I thought we might as well take that up at the same time. Now, this is my criminal jury trial week. I'm trying to start jury selection on a criminal trial, so we don't have a lot of time. All right, Ms. Merchant, I'll hear from you on your motion to unseal.
Okay, great. Thank you so much, Judge. Would you like me to podium?
Wherever you like.
Okay, thank you. I will be brief, Judge. Thank you. Judge, Rule 24 says that there's a very specific process that has to be followed for an order sealing a record. It wasn't followed in this case. It was assigned to a previous judge, Judge Angela Brown, who entered a consent order under Rule 21, granting the seal in this case. It's our understanding from emails with counsel that Mrs. Wade's lawyers do not object to that seal order being lifted. I believe Mr. Wade's lawyers do, but we believe that it should be reversed and should be lifted because it was held without a hearing. It was held, as far as I understand, without a motion, and I can't guarantee that because I don't have access to those earlier records in the case because they are sealed. But it appears it was held, it was filed without an actual court hearing where the public was allowed to be present, and so that's in violation of Rule 21. There's very specific and stringent processes that the court must follow before a record is withheld from the public, and they were not followed in this case, Judge. The first is the motion, the second is a hearing, the third is that whoever wants it sealed has to identify specific parts of the court's file that need to be sealed. Also has to delineate the nature and the duration of the seal. None of that was done in this case. And the fourth, which is the most important part of it, is the analysis that the court has to do. And what the law says in the seminal cases, Atlanta Journal versus Long, which we cited in our motion, that an order limiting access shall not be granted except upon a finding of harm otherwise resulting to the privacy of the person in interest, and that harm clearly outweighs the public interest. In this case, Judge, there's been no allegations of harm that clearly outweigh the public interest. And so the first thing to consider is whether or not that order needs to be reversed. And it's our position that it does, because it doesn't follow the law. Second, getting to whether or not an order should actually be entered now, sealing this, we do not believe that an order should be sealed.
Has anyone filed one?
No one has filed one. So if you reverse the order at that point, if someone files it, then we can litigate that. But just focusing on the reversal of the prior order, Judge, I think the law is clear that it should be reversed because none of those findings were made and the public didn't have an opportunity to be heard in that instance. And so that's in violation of the law. And there's a couple different cases, I won't belabor the point, but all of the cases on this issue hold if there wasn't a hearing, it's got to be reversed. And so we think that order should be vacated. I've prepared a proposed order unsealing that if the court is so inclined. And then if there is some type of a motion filed or an oral motion today to try and seal those records, if you are inclined to reverse, I'd like a chance to at least be heard on that as well. Thank you.
All right, thank you. Ms. Hastings, what's your position?
Your position, Your Honor. My position is that we did consent to the sealing at the beginning of the case. There was a motion filed by the plaintiff on November 18th, 2021, approximately 16 days after we filed this. We consented at the time. We have different information now. We also understand that there was no hearing conducted, so we have no objection.
Mr. Kimbrough.
Thank you, Judge. These parties did consent to this previous consent order sealing the record back in February of 2022. Judge, the divorce was filed November 2nd of 2021, answer was filed on November 30th of 2021, and this consent order sealing the record was filed on February 10th of 2022. Because it's clear that the parties' intent was at that time, and that was to protect their privacy. As such, a consent order was drafted between the attorneys who were involved at that time, of Ms. Hastings and her team were involved at that time. I was not. Did not get involved in this case until toward the end of last year. But that consent order was drafted and presented to the court, and it was signed and filed. And Judge, this court has a burden to determine what is in the best interest of these parties and what's in the best interest of this case. The law is pretty clear as far as this issue is concerned. Under the Atlanta Journal versus Long, 258 Georgia 410, it sets forth the purpose of Rule 21, which is the reason why we're here, dealing with access or limited access to court files. The purpose is, one, to protect the public right to access, which is a long-standing and traditional right, but also, Judge, that case holds that it is also to protect another traditional right, and that is the right of superior courts in exceptional cases to shield these records from public view. And the court has to weigh that. As far as this situation is concerned, the current status of this situation, that has happened since January 8th of this year, clearly shows the harm that is done to these parties and clearly gives credence to what the parties' intentions were back in February of 2022 when they entered into this agreement to seal. And we think that that it is proper for the case to remain under seal. Now, again, I was not involved back in 2022 in this matter. It is my understanding there was not a hearing that was done. It was just a consent order that was prepared and presented to the court, not this court, but prepared and presented to the court, and that order was signed off on and filed. And so we think that if this court does, based upon those facts, unseal this record, that this court should also consider putting in protections for the parties' private information pursuant to 911-7.1, which allows this court to do that. Thank you, Judge.
Your Honor, our motion is very similar.
I understand. Thank you. All right. I find that the prior order, although it was by consent of parties, was not properly entered because the Uniform Superior Court rules require a hearing to be had. We can find no evidence that any such hearing was ever had, so I'm going to grant the motion vacating the consent order, sealing the record. And I'll do that today. I'll have your written order. Ms. Merchant, unless you have something else, you're excused.
I do not. Thank you so much, Judge.
That takes care of our business. Thank you.
Yes. Well done, Counselor. Now we have Mr. Axsom's motion by a non-party deponent for protective order. Mr. Axsom and Ms. Hastings has filed a response to that. Before we get started, Mr. Axsom, Ms. Hastings, I'll go ahead and tell you both. I've read the pleadings, so you don't have to read them back to me, okay, in making your arguments. Mr. Axsom, if you would, sir, I just need for you to focus your argument today on subsection 1 of your motion for protective order, if you don't mind. So you may proceed, Mr. Axsom.
Okay, thank you, Judge. Give me 1 second. All right. Your Honor, I know that you are asking me, and I will be brief, to focus on subsection 1. I think there is some low-hanging fruit that I don't know if it's come up. I don't know if the court had the opportunity to examine it. But before we get to subsection 1, I really do apologize. I would like to handle the issue as to whether the 2 subpoenas that have been served are defective.
Well, we don't need to reach that yet, Mr. Axsom. If you'll focus your argument on subsection 1 and tell me why the protective order should be granted. If it is granted, then we don't really need to reach the subpoena argument. So like I said, press for time. This is my criminal jury trial week. Just argue subsection 1.
I sure will. All right, so dealing with subsection 1, Your Honor, which deals with 26.1. Specifically, my argument hinges on the pleadings. Now, I have not seen the pleadings, but based on the argument that I put forward, this is an uncontested, it's a no-fault divorce, and based on that, both parties have alleged that it's irretrievably broken. And because they've alleged that, and the pleadings as they stand deal specifically with whether the arguments, hang on 1 second, give me 1 second, let me hold that up. All right. The response in the plaintiff's pleadings alleges that it is permissible to bring up issues regarding the conduct of the parties. But I believe the pleadings are the things that set the boundaries. So in this case, the no-fault discovery alleging adultery is not relevant. The defendant brings up in the response that the plaintiff did not tell the defendant he was separated Plaintiff did not comply with discovery until the motion was actually filed. The plaintiff may have used marital funds for the trip, but every one of those issues involves the plaintiff's actions during divorce, had nothing to do with Ms. Willis. The issue before the court, if it's a no-fault divorce and it's irretrievably broken, is how do you divide the marital assets? And that is the issue that was brought up in the response. So specifically, we're dealing with equitable division of marital estate, the dissipation of the marital assets, and the plaintiff's capacity to provide spousal support. So those three things are the things that the court has to deal with. All of those things sit squarely with the plaintiff. Ms. Willis does not share any accounts with him. D.A. Willis does not determine what he spends his money on, no matter where it comes from. So the issue is, if it's a no fault and it's irretrievably broken, and the pleadings dictate the boundaries of the case, it's not relevant as to fault. It's not relevant as to the conduct of the parties. So that's essentially my argument with regard to the irretrievably broken in 26.1. I believe 26.1 protects, because Ms. District Attorney Fani Willis is an officer as is defined in 26.1. So it protects her. And according to 26.1b, there are two requirements that have to be met. The officer has to be high ranking, and I don't think that's in dispute. When you look at Ms. Willis and the demands on her office, Ms. Willis has Fulton County Office of the District Attorneys. The only way I can put this in context is to give you some background on that. She manages a staff of 360 plus lawyers and staff. She oversees cases right now, 20,000 open cases. She coordinates on a monthly basis at least 500 or more cases for indictment. So in this case, of course, the most recognizable issue is that she's dealing with, over in Fulton County, the election interference case involving former President Trump.
Well, I'll tell you what, Mr. Axon, let me interrupt you. Let me
Yes.
ask you just to focus on a part of the law that says the proposed opponent lacks unique personal knowledge of any matter that's relevant. Are you saying that your client lacks unique personal knowledge that could not be discovered some other way?
I would argue that she does, that the knowledge that she may or may not have, it is not unique. You've got two parties in the case, one who is alleged to have some extramarital affair with Ms. Willis. If that is the case, if that is true, he has that information. We've been at this case, well, I have, but 783 days. And on day 776, somewhere in there, we get this notice of deposition. So to focus on that part of the statute, no. I think there are other means by which that information can be retrieved in this case.
All right, thank you, Mr. Axon. Ms. Hastings? Wherever.
Your Honor, I think that you honed in on exactly what the issue is here today, naturally. The face of her pleading shows that she has unique knowledge with regards to this case. She could have filed a motion for protective order alleging all of the legal grounds for which she would like to not have to sit for a deposition, and she believes she's protected. But she didn't stop there. She went further. She asserted in her pleading, her motion for protective order to prevent herself from sitting for a deposition, that she knows the cause of the separation of these people. She knows detailed facts allegedly about their relationship. And albeit we'll deal with the falsity of those at a different hearing, that's what she said. She said it in her pleading. So on its face, her argument fails that she does not have unique knowledge with regards to the party's marriage and this situation. Beyond that, Your Honor, I would turn the court obviously to 9/11/26C and Ewing versus Ewing, which clearly states a party seeking a protective order with regards to discovery. When a party does, the trial court may make an order which justice requires to protect the party or person from annoyance, harassment, oppression, etc. However, protective orders should not be awarded when the effect is to frustrate and prevent legitimate discovery. Furthermore, the Georgia Court of Appeals has held that protective orders are intended to be protective, not prohibitive. And that's exactly what DA Willis is seeking to do in this case. She's not seeking protection, she's seeking prohibition of our ability to access facts. I can state as an officer of the court in my place here today that the first time in the 783 days that this case has been pending, the first time that I heard that the alleged cause of the separation was some false claim with regards to my client in 2017 was in her pleading. So I had questions. And that's just the beginning of it. Furthermore, Your Honor, the black letter law in the state is that in divorce cases in which equitable division of property is at issue, the conduct of the parties, including evidence of the spouse's alleged adultery, is relevant and admissible. We don't have to plead adultery in the initial petition, but we also have the ability under OCGA 9/11/15 to amend the pleadings anytime up until the entry of a pretrial order. We have the right, regardless of whether or not the grounds for divorce alleged in the petition is that the marriage is irretrievably broken, to discover information with regards to adultery. We have questions. I want to know about how he's been spending his money. I have a reason to believe he's spending it on another woman. That's my client's money. And I want to ask questions about that. She's trying to hide under the shield of her position improperly, I would suggest, Your Honor. There's a couple things that are improper about it. First of all, and I'd like for the court to clarify this, there's no doubt that she's busy. She has one of the most active district attorney offices in the state. However, as Mr. Axum cited under 9/11/26.1 D2, if you look at that, it says the person seeking the protective order had unique personal knowledge of one or more matters relevant to the subject matter. We know she did. She put it in her pleading. We also know that she did because although she asserted falsehoods in her pleading, we asserted facts in our response. And those facts, even the ones we've just shown, clearly demonstrate that she's got some unique personal knowledge in this case. But more than that, we're not seeking her deposition as the district attorney of Fulton County. We're seeking her deposition in her individual capacity as the alleged paramour of my client's husband. So whatever her job is has nothing to do with whether or not she should have to sit for this deposition. I'm sure that it's inconvenient. It's inconvenient for all of us. However, I have questions and she needs to answer them. I want to bring one other matter to the court's attention with regards to her position that I think has not been highlighted in this. With regards to her position, in her motion, page 9, top of the page, she stated unequivocally, DA Willis stated that if we pursue this subpoena, we are obstructing justice.
Yeah, Ms. Hastings, that's why I told Mr. Axum to stay away from that.
Got it.
I don't want to hear that today.
Got it. Okay. Then, Your Honor, that is our argument with regards to the propriety. It's clear that she has relevant information.
Okay, Ms. Hastings, correct me if I'm wrong, But in the over 2 years this case has been pending, we have yet to hold an evidentiary hearing where we heard testimony of either party. Is that correct?
That is correct, Your
We've
Honor.
been up to now dealing with discovery disputes.
Yes, Your Honor.
Okay. And neither party has been deposed.
Correct.
All right. Okay. Thank you.
Thank you.
Mr. Kimbrough, you have anything to add?
I do not.
You're sitting this one out?
I
Okay.
will take Mr. Clyde's reading on that.
All right. Well, both sides have good points. Ms. Hastings, I agree with. The irretrievably broken does not prohibit you from presenting evidence of adultery if that's relevant to equitable division of the marital estate or marital assets. So I agree with you there. You're not prohibited from getting into that. However, I also agree with Mr. Axon that OCGA 91126.1 is there for a reason. And the key part to me is whether the proposed opponent lacks unique personal knowledge or has unique personal knowledge of a matter that's relevant to the subject matter. And under D1 of that statute, that the party seeking the deposition has exhausted other reasonable means of discovery and found such discovery to be inadequate. So really, I'm not in a position where I have sufficient information to make a finding either way of whether the proposed opponent has unique knowledge. Because this case is a divorce, and I understand there are children, but they have attained the age of majority. So we don't have to deal with child custody or visitation or child support or who's going to have the final say on medical or educational or religious issues. So that takes out a large portion of what people normally fight over in divorces. It seems to me, and you can correct me if I'm wrong, that what we have here is a math problem. Equitable division of the marital assets after determining what they actually are, alimony, and attorney's fees. That's a mathematical equation that we need to solve. The solution will be a number or three numbers, but the numbers will be expressed in dollars and cents. And without Mr. Wade having been deposed yet or given sworn testimony yet, I'll note for the record, we have a hearing set for 9 days away where sworn testimony can be presented. Without me knowing what Mr. Wade would say, it seems to me that Mr. Wade would be the first and best source of information on what his income has been and how he's been spending it, and that he would have firsthand knowledge of whether he's engaged in an extramarital affair. Only after I hear what Mr. Wade has to say do I think I can make a determination of whether the proposed opponent has any unique knowledge about these issues. Because once again, this is a math problem and that we need to find a solution to. So with all that being said, I'm not prepared, Mr. Axum, to grant your protective order, but since the deposition is set for tomorrow and our first evidentiary hearing is set for the 31st, I will issue a stay. And I will stay the deposition until I'm in a better position to make a determination of whether the proposed opponent would have any unique knowledge, unique being the key word there, that is not possessed by Mr. Wade himself. Now, if there's not anything else, I need to seat a jury in a criminal case. Anything else?
Nothing further.
Thank you, Mr. Axon. Ms. Hastings,
Nothing further.
Mr. Kimbrough.
Nothing further, Judge. Thank you.
Y'all can email my court reporter, that'd be sufficient. Email the court reporter about the takedown. Everyone's excused. We're in recess to 1:30.
Okay, guys. So this was the hearing out of all of this talk that we've had. Let me put myself on the screen. This is the hearing related to, for those of you that's coming in. Thank you guys so much and welcome to the channel. I knew that I wanted to, my purpose of this channel, a part of the purpose is because I do like doing court hearings. Everybody doesn't necessarily want to see court hearings. And then also, you know, when you have different videos you want to play, I don't want those issues on the other channel. So I figured I'll start another one. So I'm going to back up a bit for those of you that didn't know what was going on. We know Madam DA Fani Willis is currently in a trial with Trump Rico. She hired Nathan Wade, who is a private attorney. They do that sometimes when they need additional people. They hire out from people that work at firms. He got hired in to be the special prosecutor. Apparently, either the day after or the day before that he was hired in to be the special prosecutor, he filed for divorce from his wife. When you look at the pleadings, they basically said their marriage is irretrievably broken, which is kind of a no fault line that you put. You know, people say irreconcilable differences. In Michigan, we say the bounties of matrimony have been broken. There's different ways that people say it. So basically, it's no fault. Well, apparently, somehow, I'm assuming, I'm making this up. I don't have any knowledge of this. Someone who probably don't like Madam DA advised these attorneys or advised someone, again, this is speculation because it was supposed to be someone close who knew both of them, that Madam DA and Nathan Wade, who she had just hired to be a special prosecutor, and he wasn't the only special prosecutor. There's like 3 other ones from different law firms, and told him, hey, those 2 are kicking it. So what they did in the divorce case, and now it does look a little sketchy to me because I was unaware that during this divorce proceeding that has lasted for 2 years, they have not taken any depositions of either Mr. Wade or Mrs. Wade. That is the first thing you're going to do. Why do you want to take a deposition of Fani Willis before you even take a deposition of the parties in the case? So that does make it seem like this was kind of disingenuous, trying to cause outrage and outroar and all of that. So what Fani Willis did was she got a subpoena that they wanted her to testify in the deposition. Well, first we all learned about it. Let me back up, because in the Trump case, there was a 125-page document where they were trying to get Fani Willis and her entire office basically removed from the case because of alleged misconduct. They were saying that he was paying, that she had benefits from him because they went on trips and blah, 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 blah. So therefore, there was some type of misconduct. And there was other things that they put in there. But of course, that was the salacious, and they were trying to get the case dismissed on behalf of Trump. You had other Trump defendants that joined in on it or attempted to join in on it. So then once they put it in that motion, they didn't attach any evidence. So everybody was like, you don't have any evidence to this. Like, what are you talking about? Next thing you know, Fani Willis gets subpoenaed to testify in Wade's divorce case. And they were alleging she had special information that would be helpful to the divorce. Well, what ended up happening was, so Mary said, what's unique knowledge? Unique knowledge is not what Fani has, because if she was having an affair with Wade, he would have knowledge that she wouldn't have. He would have the same knowledge she would have because she's engaged in, and he's the person in the case. That's why it sounds like a bunch of bullcrap to me, because I'm like, why would you be trying to depose her and you haven't even deposed him? Like the judge said, exactly what the judge said is what I was thinking. Nathan Wade has the exact same information that she has. In fact, he would have more. He knows what he spent his money on. He knows what accounts he has. They're not commingling their money. They're not living together. Apparently, they just kicking it. They're just dating. She has not denied that. Now, what I didn't like is I thought how I knew that it was true that Fani Willis was messing with him was because if you guys have watched Madam DA, she's very vocal. When this stuff came out about an alleged affair, her response was, I'll respond in my pleading. And when she responded in her pleading, She did a motion for a protective order, which is basically, I don't want to show up for this deposition. There is a provision for most high-ranking officials, and she is considered one because she was voted in as the DA. So she does have a high-ranking position where it's very difficult to get them to sit for a deposition because they have things to do every day, like they're busy. So unless you can't find an alternative, they're the last resort basically. And I think that's in every state because they have that here. Because I've tried to depose our mayor before and they told me to kick rocks, and I had to get somebody that was an underling as well. So I know what provision they're talking about. But nevertheless, what Wade's wife's attorney was arguing is that the information she has nothing to do with her job. So she feels like she should still sit for the deposition. To me, again, all of this is ridiculous because now that we find out that Wade has never testified, his wife has never testified in the deposition, why the heck would y'all even ask Fani Willis to test? And she was scheduled to testify tomorrow. She was actually subpoenaed to testify tomorrow. So she filed a protective order, and that's what this hearing was. And so the judge basically has ruled, hey, I don't have information. We have an evidentiary hearing set in 9 days. Wade has not testified. Perhaps there can be information that comes out then. Now, if it turns out that she has information that he doesn't have, then we'll revisit it. I highly doubt that she's going to have any information that he doesn't have that's considered unique, that she would have information about, but he wouldn't. So I would presume, even though it's been stayed, the judge has not ruled either way. So they didn't quash the motion. They didn't do the protective order and telling her she didn't have to sit for the dep. They said, we're going to wait and see what happens at this hearing. The first motion, if you guys were at the beginning, was this case was under seal. When I first found out about the divorce, y'all know I went over there to try to get them documents. And when I went over there, it kept saying under seal, and it was under seal since the case started. So I was wondering how, because typically that's public record, how they were able to finagle it being under seal and what would be the purpose. Because he wasn't even, I think it's very interesting that somehow they consented to this, I guess, and you're supposed to have a hearing because the public has a right to know what's going on in our public court system. So because of that, the media couldn't really get access, but I got all the documents just like they do. So I'm assuming somebody was leaking the documents, even though they were under seal. So the court basically granted their motion to unseal. So as of probably this afternoon, all of their court documents from this 2-year divorce is going to be available to the public. So don't be surprised if you don't start seeing them all up online now, because now it's going to be unsealed. Good morning, St. James. Andrew said, I'm pissed Jocelyn is allowing Trump's cronies to use her like this. Yes. I'm really, and you know what? I really didn't want to talk about it. That's why I did this poll, guys. And the reason why I really didn't want to talk about it is because it was kind of selfish. It was really because Black lawyers are a small percentage, but of course, Black female lawyers are even a smaller percentage. And do I always agree with how Madam DA deals with things? No, because I felt some of the things she's done, of course, just been kind of like in my opinion, she's overly doing things. But she still is a Black woman, and I'm sure it was hard to claw her way to that position. And then when I seen what it was, I'm like, so she might be kicking it with him, but everybody is pretty. Now there's discrepancies on whether he got paid more than the other prosecutors. I guess when they started out, he's always made $250 an hour, but I guess the other prosecutor made $150 an hour. So that was a discrepancy that they found allegedly, but now everybody's making the same thing right now. So there were documents that were filed, and in those documents, essentially she had this is what this hearing was. So basically we didn't get a chance to go over documents for the hearing happened because it was an emergency. And you see the judge basically was telling everybody, wrap this thing up because I got a criminal trial. So I'm gonna need you guys to wrap this up like expeditiously. He already clearly had his ruling. He already knew what he was gonna say. They just came in there just off of that. He let them know, you guys can be brief. I've read everything. And it was clear again that he had his ruling, that he was going to unseal the documents and that he wasn't going to make Fani Willis sit tomorrow for her deposition, but it was going to be stayed until it can be proven that she has unique information. That was a mess. So you say I'm sure Trump's people threw some cash the White's way, him and his peeps right dirty. But you know what, Joyce? That was my point. When you go against people when you go against big people like a Trump, know that your dirty laundry, anything, they're going to find it. They pay people to find it. They will get a PI. They will do whatever needs to be done in order to find your information. So I was a bit I was a bit upset when I found out she allowed herself to even get in this position. I'm gonna be honest, because I'm like, you already know how difficult it is, and people are on your neck. You got people breathing down your back. I'm not telling you you don't have to have a life, but damn, you got to choose somebody who was in the process of getting a divorce. So again, I don't know when they started kicking it. If it was while they were working on Trump and they was like, hey, you cute, while they was late in the midnight hour trying to do them indictments. And it's like, oh, you kind of cute too. You want to go get something to eat? I don't know if they were like kicking it beforehand or what happened, but eventually it looks like they was kicking it. That's what it looks like to me. Again, neither one of them have admitted nor denied. However, attached to one of the motions, there were bank records. There were bank records. Let me see if I can pull those up. There were bank records that were attached, credit card records, showing basically that. Did I pull that up? Let me see. I done went down a rabbit hole last night. I done pulled up all of the Eddie Long complaints. I went all over them people's complaints over there against Eddie Long, because I seen an interview that was done with one of the alleged accusers. I don't even know if I got it right now. What did I do with it? I got so much stuff on my desktop. This is ridiculous. But so I might end up having to go over Eddie Long stuff. I might do that over here. I'm not sure. Because that stuff was crazy. Because a lot of times, even with Eddie Long, we just hear the stories that people tell, but we don't. If you don't know, I wasn't following that in 2010, so I can't even find it. But anyway, they have the bank records or whatnot from alleged vacations that Fani Willis and them went on. And of course, the wife was able to get access to them credit cards. Like, you was using credit cards and stuff that your wife had access to. So when you book plane tickets, you put names on them, and her name, and I think it was like his mom or somebody went with him one time. It was him. So in Fani Willis's response, this is why they're saying she's intertwined in the relationship. And Fani Willis's response, trying to quash this motion quash this deposition so she doesn't have to sit for it. She said the reason why they were getting a divorce was because Jocelyn slept with, or had an affair rather, I think is what she used, with Nathan Wade's best friend. And she put that in the pleading. This attorney basically said, her attorney said, this is the first time we ever heard this. So because Fani Willis knows this, then clearly she has unique information. That's what she's using as unique information. But again, that would have been something Nathan Wade knew about, because the only way Fani would have known is if Nathan Wade told her. So that still wasn't a very convincing argument to me. But in their response, there was no denial that there were allegations of Jocelyn having some type of emotional affair, but she's saying she didn't sleep with them. And this was like 2017. So their argument is they went to counseling and they got over all of that stuff, even though it occurred. That wasn't the reason for the divorce. Now, Nathan Wade is alleging he never got over it. He just was trying to wait for his kids to be in the majority. So honestly, it looks like, from my understanding, Nathan Wade has done family law. Nathan Wade was not about to divorce his wife. This is just my opinion. While they had minor kids, because apparently he wasn't about to be kicking out that child support. That's just my assessment. So I think she thought that they was perhaps getting over whatever happened, where it was they were talking on the phone or whatever it was. But dudes don't get over affairs like that. They want women to get over stuff, but they can't get over even the thought of you being with another man. Now, again, she alleges they never slept together. They just had an emotional affair, and they were talking on the phone and all of that good stuff. But apparently, it looks like Nathan Wade just waited until them kids got of age so he ain't have to pay for them. That's what it looked like to me. So, but that's that. Y'all make sure you hit the like button. We got more that we gonna try to do over here. I'll try to post on the main page. I'm gonna try to go live tonight and go over these video calls that just came out on Ernesto. I got to get some watch hours over on this page, but I'll continue to do the majority of Ernesto stuff on the main page, but I'll try to post and let you guys know when I come over here, because I don't know if you guys are going to end up getting notifications or whatever. But yeah, you said P. Holland said the math is not mathing. So yeah, so what they're basically saying is, you said she paid him back for the tickets. You know what? That would be a good argument, though. So what Trump's camp is trying to use this as, because clearly there's not really illegal for her to be kicking it with them. I don't see anything. Maybe they may look into an ethics thing, but legally, nah. Not to dismiss a whole case. That's just crazy to me. But again, I'm mad that DA Willis even got herself into this pickle right here. But what I can say is what they're trying to allege on the Trump end in their motion. Now, they have a hearing coming, and we'll stream it here. February 2nd, I think she has to reply to their motion, which started all of this firestorm. And then they have a hearing like on the 12th or the 15th or something like that in February. So we're gonna, we'll revisit that. But what they're trying to allege is because he made over $650,000 since he's been the special prosecutor, they went on trips. He probably paid for them trips with the money that came from the county. So she's basically benefiting. They're also challenging Nathan Wade's credentials as it pertains to being qualified to even do a RICO case, because he's never done a RICO case before. So they're saying because of the relationship, he got the job, is what they're alleging. And she's benefiting because if you're going to pay this man $250 an hour and he billing a quadrillion hours, and then y'all going to Aruba and San Jose and all these other places y'all allegedly went, and I'm making those names up. I don't know where they went, but they supposedly went to a handful of places together. And her name was on the actual plane tickets as being there. Then they're saying that, you benefited from this. So that's how Trump is trying to swing this. So it's just a bunch of smoke and mirror. A lot of it is smoke and mirror. And so that's that. Y'all got any questions related to these shenanigans? They say she paid 6 times more than the others. Well, my understanding is from the beginning, one of the guys got paid $150 an hour. He got paid $250. Then the guy eventually went up to $200 an hour. Wade apparently got paid $250 from the jump, allegedly. Deborah said, please, he is over. I was about to say he was a judge. I do recall he was a judge. And I know he did family law in his own law firm. And before that, he's actually been a special prosecutor in Cobb County before. Because I seen a lawsuit when he was over, I think it was some FOIA request or something with the jail. So yeah, this isn't the first time he's been hired. I don't know if they called it a special prosecutor. He was hired as something from that county in Cobb. or was it Cobb? Yeah, Cobb, because that's where he got sworn in at. Yeah. Yep. You said pillow talk. Totally Tori said pillow talk. This is messy. Child. It sure is. And sure, that's what I said. A lot of this stuff is just smoke and mirror, and I think they're just doing now. Her standing up on her being DA Fani Willis, standing up on Martin Luther King and saying this is because the color of my skin. Child, if you was white and you was coming for Trump, they still would try to dig all of this dirt up. It's politics, you know. That's what politics is. They try to find out when you stole candy in elementary school with your homegirl, when you stole the annihilators. That's what they do in politics. It's a dirty game, and you're actually you have charged and you are trying a politician, formerly the president of the United States of America. So I don't know why this wasn't thought of, but I think it says a lot too that people around you leaked this information that you guys were kicking it like that. Because I wouldn't have known, you wouldn't have known, but for somebody telling, Wade's attorney that. And then, so, fault, even if you have a no-fault divorce basically means I'm not going to say the reason why the divorce is your fault or my fault. However, because we're considered in Michigan a no-fault state. So all you have to do is put the same little phrase. If one person don't want to get a divorce, it does not matter. You still are entitled to get a divorce. Because you do have sometimes when the other party don't want it, all of that stuff. They cannot contest it to that point where you just can't get a physical divorce. Now, when it actually comes to, sorry, got my office phone connected to my computer. When it comes to marital assets, and that is what Jocelyn Wade's attorney was speaking of, you do look at fault. So you have different prongs. So for instance, if you were committing adultery and you decided you want to give your partner a high-rise apartment downtown Detroit, and you're using money that is considered marital property to go fund it, then you're going to have a lopsided division because, baby, you're going to have to pay back all the money you spent for that. So she has a valid argument when it comes to that if money was spent on this woman that came from the marital assets or came from marital property, then that will affect division of property. However, you don't need Fani Willis for that. That is something that Nathan Wade should be able to testify to on his own self, whether he had an affair. I'm sure when that hearing comes, they'll probably be streaming that in 9 days. And when they do, we'll be over here streaming it too, because I want to know what they're going to talk about in the evidentiary hearing. And now that it's not sealed, then all of this stuff is public. So basically what reporters do in Georgia is they file what's called a Rule 22, and that gives them access to be able to stream like what we did. I shared a stream. But when I've done it with the hearing for Ernesto, that's what I did, was put in what needed to be done so you can get access as the media to what's going on. So they've already, the media probably didn't even care about that man's divorce until Trump's attorney did what he did, filing that motion. So now we have a whole clown show, and we're going to be all up in their divorce business when it would have been private, but for this motion coming out. Well, yeah. You said as messy as Fani's situation with Nathan is, Trump is clearly afraid of her, and his team will pull out all the stops to get off this. Yes, I agree with you, Marnie. You start playing dirty when you don't have the law on your side. A lot of people start playing, and that's what they do in politics. When they're not beating you on the campaign trail, then we're going to find, remember when they had all the women that accused, was it Bill Clinton? They accused Bill Clinton of different assaults or whatnot. And when Hillary Clinton was running, they had all the women come to the debate and sit on the front row. That's the type of stuff that they do. Has nothing to do with what you're trying to do. Has nothing to do with the real substantive issue. It's all about, it's a distraction. It's a red herring. And the judge actually seemed a little irritated. I don't know if you guys picked it up, but the judge seems a bit annoyed to me. He seemed a bit annoyed. Like, okay, I have a jury trial, so we're going to wrap this up mighty quickly. And as you see, he did it in like 30 minutes. And this has been the talk of the town for what? At least 2-3 weeks. This has been the main talk of the town. So, yeah, make sure y'all hit that like button. So, yeah, so my intent is to come on later. Make sure you guys hit the like button. Thank you guys for subscribing. I appreciate it. I am going to probably go back in so I can add mods on here because I don't have any mods. I think I can do it this early. I'm not sure because I've just started this page yesterday. But thank you guys. We already rocking over 1,000 and we just started yesterday. So thank you guys for your support. Deborah says she wants alimony. The judge knows it's BS. Renee, see you later. You guys have a good day. Hopefully we'll see you guys later. Again, I think I'm going to go over some of the video calls. Looks like it was one that I missed while I was on here. But phone calls from prison is just dropping them joints. It looks like she's going to be dropping them all day because maybe they're easier where she's just putting them. She doesn't have to really edit it like she does the phone calls. And then they're 30 minutes. So, yeah, we'll pick 1 or 2 to go over today, hopefully tonight, if I get my work done. But thank you guys for joining me. I appreciate it. You guys have a good day. I'm going to talk to you guys later.